120 words per minute for 10 minutes. 15 seconds more. Five seconds. Start. The present writ petition has been filed by the petitioner challenging the order passed by the learned debt recovery appellant tribunal. The facts as noted from the record are that the bank had filed an original application before the DRT for recovery of money due from the petitioner along with interest. The said OA was allowed by the Debt Recovery Tribunal. The petitioner has filed an appeal before the DRAT. It appears that the said appeal has come up for hearing along with the IA, which was an application for waiver of pre-deposit. The DRAT directing the compliance of the condition of pre-deposit as provided under Section 21 of the RDDB Act 1993 in August 2018. On the failure of the appellant to make the pre-deposit, the appeal was dismissed as being not maintainable. The facts as averred by the petitioner are that the petitioner maintains a current account in the respondent number 2 bank with admittedly no overdraft facility. The petitioner started providing technical services like software feeds and uplinking services. The petitioner provided a security check for an amount of rupees 2 crores drawn on the respondent number 3 bank in favor of the predecessor in interest of the respondent number 3 as collateral security for the future business engagements of the petitioner. It is the case of the petitioner. The aforesaid security check was replaced by the petitioner with a check drawn on the respondent number 2 bank in favor of the respondent number 3 for an amount of rupees 2 crores with a clear understanding that the said check would not be presented for encashment as it was a collateral security. It is the case of the petitioner that the respondent number 3 illegally presented the said check for encashment to the respondent number 2 bank when admittedly carry forward balance of the petitioner's bank account with the respondent number 2 was around rupees 300. The respondent number 2 illegally cleared the check despite the petitioner not having availed any overdraft facility in its current account with it. In June 2002, the petitioner received a legal notice from the respondent number 2 bank calling upon the petitioner to pay the amount of the aforesaid security check, which according to the bank had been honored by mistake despite the petitioner's current account having insufficient balance. In July 2002, the petitioner replied to the aforesaid legal notice denying any debt or liability to pay the claimed amount to the respondent number 2 bank, since the petitioner had never availed any overdraft facility in its current account maintained with the respondent number 2. The respondent number 2 bank responded to the aforesaid reply of the petitioner to legal notice stating therein that once a check is issued, there is a mandate to honor the same. Thereafter, the respondent number 2 bank filed an OA before the learned DRT, which was later transferred to learned DRT 1 Delhi. The petitioner filed its written statement to the OA filed by the respondent number 2 bank. The petitioner filed an IA challenging the jurisdiction of the DRT on the ground that the amount claimed by the respondent number 2 bank does not qualify as a debt under Section 2G of the Act of 1993. In February 2006, the learned DRT stated that the IA would only be decided after the petitioner files the written statement. The petitioner's case is that it filed its reply cum counterclaim to the original application filed before the learned DRT by the respondent number 2 bank, wherein it again objected to the jurisdiction of the learned DRT to proceed with the matter and also brought to light the collusion between respondent number 2 bank and respondent number 3 in illegally clearing the said check. The learned DRT, vide its order in November 2009, dismissed the IA and held that the issue relating to jurisdiction would automatically be taken up through the final arguments. The learned DRT decided the TA in July 2017, in which it held that the petitioner and the respondent number 3 are jointly and severally liable to pay to the respondent number 4 bank a decretal amount of rupees 4 crores along with pendant life and future interest at 11% per annum. In the aforesaid facts, the petitioner also submits that the DRT had no jurisdiction to entertain the OA as the petitioner did not owe any debt to the respondent number 2 bank in terms of section 2G of Act of 1993. Further, the bank's claim must arise from business activity, since this issue goes to the root as to the maintainability of the OA under the Act of 1993. The provision of appeal under the Act could not have been invoked. That apart, he states that even the finding of the tribunal that the petitioner and the respondent number 3 are jointly and severally liable is also untenable. We are not impressed by the submissions made by the petitioner, firstly, for the reason that the petitioner is stopped from taking the plea that the DRT did not have the jurisdiction as the petitioner did not owe any debt to the respondent number 2 bank. This we say so firstly because against the order of the DRT, petitioner had filed an appeal before the DRAT as the DRAT was insisting upon the pre-deposit to be made by the petitioner, and the petitioner having not made the same, the appeal was dismissed. On such dismissal, the petitioner has approached this court. So, having submitted to the jurisdiction of the DRAT, such a plea is unsustainable. Secondly, even otherwise, the plea of the petitioner that the petitioner does not owe a debt to the respondent number 2 bank is also not appealing. The DRT had rightly relied upon the judgment of the coordinate bench of this court, wherein this court held that the RDD-BFI Act was enacted to provide for expeditious adjudication and recovery of debts due to the banks and financial institutions. The definition of the expression debt as given in the Act defines it to mean any liability which is claimed by the applicant bank or a financial institution, as the case may be, as due resulting from any business activity undertaken by the bank and subsisting as indeed legally recoverable on the date of the application. So, the issue of jurisdiction of the DRT to entertain the OA being well settled, the question whether the tribunal was right in holding the petitioner and the respondent number 3 are jointly and severally liable, or it is only the respondent number 3 as put by the petitioner by relying on section 72 of the Indian Contract Act, is the issue relatable to the merit of the dispute. The tribunal has taken a view. The legality of the view can only be considered by the DRAT in an appeal as per the provisions of the Act of 1993, which remedy as per Supreme Court is mandatory. The petitioner, having availed the remedy by filing the appeal but got the same dismissed by not making the mandatory pre-deposit, cannot now agitate or challenge the findings of the tribunal in this writ petition. The DRAT had rightly dismissed the appeal. Surely, this court cannot allow the petitioner to bypass the process of appeal and agitate the issue in these proceedings. We do not see any merit in the petition. The same is dismissed.